Let us see what is important in CR.P.C for men's examination. While discussing this, what is important for men's examination, I will be telling you a little bit of the procedure also, so that you can understand the real context of question. The moment I talk of CR.P.C, I begin with the offense. So the moment offense is committed, we initiate proceeding and process in CR.P.C. जैसे ही कोई अपराध होता है, आप पुलिस वाले के पास जाते हैं या मैजिस्ट्रेट के पास जाते हैं, CR.P.C की शुरुआत बेसिकली यहीं से होती है. अब देखिए, मेंस एग्जामिनेशन आप दे रहे हैं तो उस हिसाब से आपको ध्यान रखना है. तो जैसे ही ऑफेंस होगा एंड यू गो टू पुलिस नाउ स्टेशन और यू गो टू पुलिस or you go to magistrate. So the moment you go to police or you go to magistrate, there are two important now areas of question here. If you go to police station, the story is from 154 to 176 contained in chapter 12 of CR.P.C. And if you go to magistrate, this is there in section 202, 203. That is chapter 15 of CR.P.C. I hope I will be correct, but if I am incorrect, you will correct yourself. Or you will correct me as well. So magistrate को आप क्या देंगे? Magistrate को आप complaint देंगे. Now, हालांकि wrongly many people will say that I have filed complaint with police, but complaint is not given to police. Police is given information. There is no complaint to police, but people will largely and loosely speak so. But that is not proper, that is not fair. You give information to police and you give complaint to magistrate. But many people will say that I have given complaint to police. So not at all an issue for us because we are studying law, so we will be correcting ourselves here and there. But I said that there are two areas of question. Now what are the areas of question in 154 to 176? This is prolific area of question in men's examination 154 to 176. Now let me devote some time to this. So if I go to chapter 12 of police investigation, 154 to 176, what are the questions of examination? I may not be very exhaustive, but I will be indicative and I will tell you exactly what are the questions. If you concentrate on those questions, I think men's examination is cakewalk as far as CR.P.C is concerned. So first question is on FIR itself. Now generally good examiner and good examination will never ask you such question, what do you mean by FIR? They may ask you applied questions on FIR. That see, this is the information given, will you register FIR or not? So basically they will ask you question on twin test of FIR. And what is that twin test of FIR? You will come to know when you read FIR. Basically it is that it should reflect cognizable offense, number one. And number two, it should be prompt. So promptitude and identification of cognizable offense is the twin test of FIR. But we will be discussing that in great detail later on. Now then there will be question, what is the evidentiary value of FIR? So identification and determination whether this information constitute an FIR or not. And then the related question that whether there is evidentiary, what is the evidentiary value of FIR, you will discuss in great detail. And then there can be question which has of late arisen here and there. I think even now, today in newspaper I read that police is saying that I need to do preliminary inquiry before registering FIR in case of this allegation made by lady wrestlers against the wrestling coach. So there was the news in the newspaper. So there can be question like that, in which cases preliminary inquiry for registration of FIR is necessary. So variety of questions may be asked, but you should not be baffled by those variety of questions because they are all interlinked and related and they will be answered at one point of time. When you move forward, then there can be question on 164, that is recording of confession. So many questions are there. Who can record, how he can record, what procedure he is required to record, now follow, what safeguards he is required to follow, and what is the evidentiary value of that confession. If it is recorded by a magistrate incompetent, what will happen? If it is not recorded according to the procedure prescribed, what will happen? Now, can you go straightway to magistrate to record confession without police sponsoring you? What will be value of that confession? So, variety of questions again. 164 is another prolific area of question. It raises versatile various issues. So, you will have to be very, very careful. Then the third area of question is 167. Now, see, recently we have raised a debate on 167. And the debate is that you are saying that the police remand can be in first 15 days only. And the accused is not available for investigation and for interrogation for first 15 days on this pretext or that pretext. That happens sometimes. Accused is too smart. He goes for some kind of medical treatment and there are some other issues and he is not available to police. Police has not been able to now inquire and interrogate him. So what is the use of this prescription of 15 days? Because the investigation is not complete. So one bench of Supreme Court, division bench of Supreme Court has raised this question that we are required to look into this law of now prescribed period of first 15 days for police remand. So this issue is very, very important. Then the next area of question is on 173, that is charge sheet. 172 is also important case diary, but there can be question of short notes kind. It doesn't raise critical question, but 173 is another prolific area of question. Other questions are of short notes kind. Now 173, what kind of questions? I tell you that when can you file supplementary charge sheet? Can we file interim charge sheet? Whether the police is bound to take order from magistrate if it goes for further investigation. Can police file incomplete charge sheet in 173 just to avoid and just to evade the procedure of default bail or statutory bail prescribed under section 167? Can it be allowed to happen? Is it not interfering with the fairness of the process prescribed in 167, which puts pressure on police to complete its investigation within 60 days or 90 days? So it is very, very important issue right now. 173 read with 167. Now, charge sheet means complete charge sheet. It does not mean incomplete charge sheet. Now, even today, Ravi Chavadia versus Ritu Chavadia versus Union of India, 2023 Supreme Court decision. Then there are other questions like 172, 174, 176, or even maybe now other questions like 156. 156 has been another important area. This can be now short notes kind of question. This is what is important in mains examination. Now, when you read these things in great detail, obviously, I will suggest all the students and even the teachers that if you are reading this police investigation, you are required to devote enormous time on 154, 164, 167, and this will consume one separate lecture on each topic like this: 154, 164, 167, and obviously 173. So this chapter is going to consume a lot of time, maybe 7 days at least. I said at least. This may be even more if you discuss more and more cases. So this is one of the most important chapter. Many people will not appreciate and they will say ये section आपने पढ़ लिया 10 मिनट में और वो section 10 घंटे में. So this is what is the irony. You are required to understand what is important for examination and for process as well. Now I move forward, chapter 13, jurisdiction. The moment you have done investigation, obviously the question is of jurisdiction, which court to approach. And this issue of jurisdiction prescribed in chapter 13 is coterminous with jurisdiction prescribed in chapter 12 of CR.P.C. And in this context, the question is raised whether the concept of zero FIR is reasonable or not. Because you can ask me to register FIR, but what is the utility and importance of registering zero FIR, because there is no use of investigation in that case. So what is the use of reporting of the case and writing of the information by the police in that case? We don't understand much. We'll explain this in our class whenever we take that issue in our class. But just to inform you that this matter of jurisdiction is coterminous with police jurisdiction as well. So you will keep in mind, this is not only magisterial jurisdiction, this is also police jurisdiction. Chapter 13 has 13 sections for your kind information, but these all 13 sections are not important. If I remember correctly, 177 is a general question that every crime should be now inquired and tried by the magistrate where it has been committed. So basically, criminal law deals with territorial things and it has territorial jurisdiction. If the crime is committed here, why the judge of other case or other court or other place will try this? This is logical. This is quite reasonable. But 178, 179, 180, 181, 182, 183, all these are somehow provisos and they all may be relevant for you. Now, if I remember correctly, in Haryana, I have seen many questions on jurisdiction. Many questions. In other examinations, I did not find so many questions. Theoretical question may be there. So you just prepare theory question, what 177 says, what 178 says. 178 is basically UPSC. Uncertain, partial, several, continuum, something like that. 179 now, consequence. So you will remember that is not an issue at all. 181 has 5 subsections, if I remember correctly. You will remember all those. There are tricks and techniques I have written in my barrack in my material too. So if you are interested, you can look into that. 178, 79, 80, 81, these are relevant. These are relevant for your examination. But it will formulate now one main question and other subsidiary, supplemental, auxiliary questions. Auxiliary questions, and this will be relevant even for preliminary. Now then see, chapter 14, cognizance, very important task of a magistrate. I tell you, CR.P.C did not prescribe any limitation on filing of charge sheet, though it prescribed limitation of completion of investigation within 60 days or 90 days. This was just to put pressure on police to complete investigation and file charge sheet as soon as possible. But charge sheet is to be filed within a minimum period, it is nowhere prescribed. But if you talk of cognizance, there are so many limitations on taking cognizance, so many limitations. One limitation which I remember is related to time prescribed in that 467 to 473. 467 to 473. That is chapter 36 of CR.P.C. Another limitation is here in this chapter, which we are going to look into, chapter 14 of CR.P.C. section 190 to section 199. Memorization of these sections are not very difficult task if you understand the logic, you understand the arrangement of sections here and there. So 190 general provision, it says on what ground you will take cognizance. And sometimes I must tell you, the words of CR.P.C may be now misleading and may be confusing, because if I remember correctly, 190 says that the magistrate may take cognizance. Does it mean that magistrate may not take cognizance? I don't think so. So this statutory law has to be read along with the Supreme Court, High Court decisions where the law has been clarified. You must be very clear about this. You just see the grounds. I am just discussing the question right now. 190, how will you take cognizance? Who will take cognizance? On what ground you will take cognizance? Now, all these questions, supplementary, subsidiary questions, not very important, but 190 as a section is very, very important. Then what is important in this? I tell you, 195 to 199 prescribes limitations. This is very, very important. This is very important for understanding of this procedural law as a member of bar, as a member of bench, and even for students, it's very, very important for your examination. And there may be questions on 197, public servant, you have to take permission of concerned authority before taking cognizance and initiation of proceeding. So 197 is important, 195 is important, 198, I think, marriage related provisions. Then this 199, that is defamation of higher dignitary. You know, defamation is in very much news right now. Huh? So just keep in mind these questions can be important. 197, 199. Now then, chapter 15 of CR.P.C. 200 to 203. Now you do not have confidence in police, you go and you file a complaint. You can adopt this process also. And when you file complaint and you have magistrate does not have any evidence, like police investigation collects evidence and submits it to magistrate in case of police report. So now here magistrate will examine complainant and witnesses too. Examine complainant and witnesses too. So this is the procedure of filing complaint before magistrate, and complaint is always, so an individual has two-way now option. Either he can go to police in chapter 12, 154, 55, or he can go to magistrate in section 200 of CR.P.C. If he goes to magistrate, magistrate has to examine him. He will also ask for some evidence. He will also ask for document, etc., etc. And if he thinks fit, he can order even investigation in 202. You might be aware of that. So there can be question on this now part also. And there can be one more question. Suppose police has investigated a case and police has filed a closure report and you are not satisfied. Now then can you file the complaint? The answer is yes. You can file a protest petition. And this protest petition is treated as complaint in section 200. This can be a good men's question. Can we file second complaint on the same issue? So these are the issues which will arise in the court and which is raised in question as question in examination also. What are the procedures now? Can you file second complaint? Can you file protest petition? Can magistrate order investigation? And there is requirement of examination of all witnesses. If magistrate has not examined all witnesses, or even session court has not examined all witnesses, then what will be impact of that non-examination of all witnesses? You will find all these questions in 202. I'll tell you when I'll teach you that. So, chapter 12 you have seen, 13 you saw, 14, 15. Now 16. 16 doesn't have much. It is not important for men's examination. But you will read this as a procedure. Now commencement of proceeding. So you issue summons, you issue warrant. Now law of summons and warrant is written here. Now in summons cases, summons shall be issued. In warrant case, warrant may be issued. And if you think fit, then even in now summons case, warrant can be issued. You can look into section 89 of CR.P.C, 88 of CR.P.C, I'll tell you that. So they may be relevant. Now to call the persons, we have approach of summons, we have approach of warrant. Now we can also now adopt the method of proclamation. You can also go for attachment. Now something like that, 82, 83, warrant is 70 to 81, summons is 61 to 69, something like that. Then bond also 88. So these are different methods to call the people. So in chapter 16 you have this 204 to 210, but this will be read along with this. Whether personal appearance is required or not, in some cases it may be excused. 205. Supply of copies in 207 to ensure principle of natural justice. We'll see that. We'll see that. I hope you understand little bit process also how it moves. No? So after taking cognizance, you have issued this summons and warrant Now in 204, and then you supply the copies in 207, 208, 209 talks of commitment of case, all these related provisions. Once this is done, accused comes before you by now this summons or warrant or attachment or proclamation, whatever. And then you initiate the process of charge framing. You initiate the process of charge framing. So you just have a look. 12 was investigation, 13 was jurisdiction, 14 was cognizance, 15 was complaint, 16 was initiation of proceeding before court. Now 17 is charge. People will say, I don't remember. Now you can remember easily everything, 211 to 224. Even within this, you will find that there are two parts. 211 to 217 is one part, and 218 to 224 is another part. Adopt library technology if you want to memorize the sections. So charge can be an important question. And this is the first and foremost task of a judicial magistrate or the judge in his court or in her court. So you will be taught in Judicial Academy about this framing of charges, what ways to be taken care of. There are form related to this also in your Bear Act, form number 32. How the charge is to be framed, it has to be specific. You will be required to study the definition of charge also. It is precise formulation of a specific accusation against a particular person. A charge cannot be prepared in vague. A case can be filed against unnamed persons. There can be a named FIR, but there can be no unnamed charge. How will you charge a person when you do not know who is to be charged? So this is what is principle of natural justice. You will read about this. The general question is expected that what are the different things to be taken care of in framing of charges? What is the effect of error in charge? If the error is immaterial, if the error is material, what will happen? 215 you will find this there. Error is material, error is immaterial. Obviously, if error is immaterial, it is immaterial. If error is material, then it is material, then the charge is defective. Then there is provision of alteration of charge in 216. Then there is procedure for that alteration of charge in 217. No? And 218, these are joinder of charges. First, it says that there should be separate charge for separate offense, but if it serves the purpose of justice, then there can be addition of charges also. So you will read about this in chapter 17. Now then, once the charge is framed, then as I said in the beginning, or you might be knowing that there are two kind of cases, warrant and summons. So depending upon the gravity of offense, one case is warrant, one case is summon. So warrant cases will be tried either at session trial or as warrant trial. And in summons case, you will be having summons trial or summary trial. So fourfold trial method can be an important question in examination. But generally, I have not seen very much question on this, but I will recommend you to read it very, very carefully, because this is one of the most important understanding of CR.P.C as a judge, because judge is required to conduct trial. So questions will be very general. Who will be trying the case, which cases, what will be the procedure? So I think generally you are all aware. Session is for gravest case, warrant trial is for little lesser, summons is for even lesser, and summary is for even lesser. And summary is faster trial. That is why in new CR.P.C, the scope of summary trial has been enlarged, so that we can expedite the method, we can expedite the process. So sessions trial, warrant trial. Now if you see sessions trial, this is 18, this is 19, this is 20, this is 21. This is chapter number. It's very easy to remember everything. This begins from 225 and it goes up to 237. It is from 238 to 250, I hope, 251 to 259, and this is 260 to 265. Practice makes a person perfect. So you have become perfect. 18, 19, 20, and now this is not cut. This is 20, this is 21, this is same. In all trial process, you will take care of principal features of fair trial. And what is principal feature? You cannot be judged in your case, your own case 479. You give me proper information, 207 supply of copies. If there is no case made out, you will not frame charge against me, this is discharge. Either it is 227 of sessions trial or a warrant trial. Now I tell you, in warrant cases we frame formal charges because framing of formal charge will also consume time. If you go to court, you will be under disbelief that framing of charge may take number of years. I was reading a case in one of the newspaper where I found that one trial began in 1991 and it ended around 2022. So this is unbelievable. You have taken almost 31, 32 years to complete a trial process. So it's a very long, lethargic process. And CR.P.C wants you to conduct a speedy trial. That is why you might have read a news that one judge decided a case in one day. And somehow the case reached to the Supreme Court. Supreme Court did not say that this is wrong. Unduly haste is bad, I know. But if something is very clear and I have no doubt, I can render my judgment immediately. Will you wait for a number of years to pronounce a judgment? But this is how we have been trained. So we are required to train ourselves in different way. And this is the task of judicial officers of this country, that they should understand that their duty is very important. They are going to change the entire India. So if this is the sense, you will be doing great job. And if you think that you are just working for some money and you are getting the salary and you are doing the work, then it will not change your country at all. So session trial, warrant trial, everywhere you will find that there is prescribed procedure which ensures fair trial. And when I say fair trial, the first fair trial criteria is that charge should be framed properly and it should be framed in your presence. You will be given time to bring your evidence, then the other party will be given time to bring their evidence. So first prosecution evidence, then defense evidence. And I tell you, in sessions trial, if prosecution evidence is not up to the mark, then there is no need of defense, because it is gravest case. So we need to be very, very careful about this. So be careful. These all trial processes can be important question in your examination, and they may ask you question, what are the features of this trial and how these trials are different. Even in warrant trial, you have two processes, warrant trial on police report and warrant trial otherwise than on police report. So they may ask you difference question there also. They may ask you question on what is the difference between warrant and summons case. They may ask you question on what is the difference between summons and summary case. So difference based question is very, very important in this particular chapter 18, 19, 20 and 21. Now, offlet, plea bargaining is very, very important, chapter 21a. So, I will recommend you to write procedure of plea bargaining. So, see, this is what is important in your CR.P.C. You prepare a short note. But apart from this, there are certain other questions which I must quickly tell you. If I start from the very beginning, I find arrest provisions are very important. And in that, a particular question may be asked, what are the different rights of arrested person? Different rights of arrested person. Different safeguards, that is what is rights. And what is the procedure to be adopted by police? Procedure for police and rights for arrested person. These are the two limbs of question. When I move further, the question may be, on maintenance, who can be awarded maintenance now? Divorced wife or person living in live-in relation. Prolonged living together will constitute the relationship of husband and wife or not? Can parents seek maintenance or not? Can a husband ask for maintenance or not? All those questions. Who can seek maintenance? And what will be now criteria to decide maintenance question? But there may be a question on alteration of maintenance amount. Alteration of maintenance amount. Then bail is very important area of question. Special powers in 439 and anticipatory bail in 438. And 437 too, criteria of granting bail. And this is again evolving bail jurisprudence which is being rendered by many decisions of the court, so you are required to be very, very careful in this regard. How the bail journey has started from the very beginning and how this is moving forward, you are required to understand that. You are required to understand that. So bail is very, very important provision. Bail is very, very important. Then the question will be on this section 320, compounding of offences. Very important. 320. Section 300. Now these are short questions. 320, 300, 319. There can be question withdrawal from prosecution. Addition of accused in 319. Short questions. Addition of accused in 319. Withdrawal of prosecution. Withdrawal from prosecution and addition of accused, I said. You might have read the section, you might have noted down. Addition of accused 319, I said. There are recent decisions of Supreme Court on this point also. And withdrawal from prosecution, you can see 321 and 223, something like that. So that is also important. Short questions. 320 I have said, 300 I have said. See, 311 has also been issue of let. 311, that is court witness. 313 is very important in your trial process, because after defense, prosecution evidence, you ask the concerned accused that whether you have understood this prosecution evidence in 313 or not. Very, very important thing. And then the general question of provision regarding appeal, reference, revision. Revision is very much in practice. When you go to court, you will find it there. Appeal is very much in practice. As a lawyer, as a judge, you should understand the provision of appeal. When appeal can be filed, on what ground appeal can be filed, when appeal against acquittal, when appeal against conviction. Many examination will not ask you, but many examination will ask you. Especially those who are preparing for higher judicial services, they must know this appeal, reference, review, revision. Review is not so much in CR.P.C, but revision is there. Revision is there. Now 482, inherent power of court, very, very important. 482. Inherent power of court. Limitation provision is very important. Men's preliminary both. Then of late 156.3, I have said this is important, again and again question. 173.8, again and again issue is being raised. So these are the pockets which we are required to understand, which is in current context, which is in current news. 482 is also in current news. 395, 401. I think if you read this much, it will suffice, but just let me check once. Bail I have already said. Then, of course, as a lawyer, as a judge, as a student of law, you should understand how to write judgment. So, how to write criminal judgment? Now, see, any judgment will have fourfold parts. Fact, decision, reason. It is general. It is general. If you read any judgment, you will find it. Judgment writing can be learnt only by reading judgment. It cannot be learnt by reading books. So there are many books on judgment writing, but that is not useful. You read judgments. And if you read judgment, you will understand that. I hope this is all for now, this men's examination. Thank you very much.